Welcome to the Development Bank of Jamaica's Intellectual Property Webinar Series, hosted in collaboration with the Jamaica Intellectual Property Office. I am Lashana Chetty Singh, Technical Coordinator in the Big E program, and I will be your moderator today. The Development Bank of Jamaica in 2022 launched its Patent Grant Fund, and to date we have supported over 7 innovators with grant funding up to $4 million each. And a part of our sensitization program for inventors and researchers, we have partnered with JIPO to present you with a series of webinars. You may be asking, what is a utility model? Well, we have our presenter, Mr. Jason Wongsam, from the Jamaica Intellectual Property Office, and he will be taking us through what exactly is a utility model, how to maneuver your applications, and of course the benefits to innovators and researchers. Later on, we will have a pre-discussion with our beneficiary from Zermasol, Mr. Rayvon Stewart, and the team, who will take us through his journey from being a student at the University of Technology, participating in the National Business Model Competition, to now being a beneficiary under the Patent Grant Fund, and how it has helped his company to position themselves to attract investors. I will now hand over to Mr. Wongsam, who will take us through the presentation today, Understanding Utility Models.
Thank you, Lashana. Good morning, everybody, and it's great to be here. Thank you for having us today to be a part of what I consider a very important aspect of our new law that came about in 2020. And this is a very new area of intellectual property to Jamaica. So the idea is to get our innovators and inventors familiar with this aspect of intellectual property, right? So what is a utility model, really? So a utility model really is, it's an IP right. It's kind of like a patent for a new technical invention, right? So when you're looking at a utility model, it has a similar properties as a patent, but it is for what you would consider incremental improvements for the patent, right, or the innovation, right? You can file your utility model at the Jamaica Intellectual Property Office. This is the only place right now where you can apply for the utility model, and that is very important that you have to come to JIPO, and it's advisable that you come to JIPO and you get the relevant information as to how you go about filing your utility model, right? So what are the differences between utility model and patents? Well, this is why we're here today. Why do I file a patent versus a utility model? So what are the benefits for a patent or a utility model, right? So first and foremost, the requirements for a utility model are less stringent than that of a patent, meaning that you're going to still have to file the same kind of documentation as a patent because they're very similar, but the requirements for a utility model are less stringent, meaning that it's easier to acquire a utility model than it is a patent. So this is a benefit, especially if you don't have the benefit of getting a developed specification as yet, or you don't have the resources to get a developed specification as yet. A utility model might be a better alternative for you, right? While novelty is always a must, you have to look at the novelty of your invention, right? The novelty is basically it must be new. So when you're looking at a utility model, it must be new. It can't be something that you saw somewhere. It can't be something that you've actually merged it into a watch. So that's an incremental improvement that you could say, and you have it. So you're going to lay out the title, you're going to lay out the inventors or the inventor, right? So you're going to say who are the inventors, their addresses, so that we can know who the inventors are. If you're acting with an agent, you're going to tell us who that agent is. So these things are very similar to the patent, right? You're going to give me today. Or have I pressed it too many times now? No? There we go. I just needed to give it some time. Right? I've come up with a top to go on the pen to prevent the ink from drying up. So, but I'm sure you guys are too wide, but I can speak to the people here. What do you think? Utility model or patent? I have some people in the audience, and I'm just going to poll the audience. Utility model or patent? Patent? Okay, I'm getting a lot of patents. Looking at it, it functions the same way, right? It functions the same way, it carries you, right? But it actually probably is a utility model because there's no improvement, right? Maybe the improvement, I don't know, maybe it gets more miles to the gallon on that, but that is a definite incremental improvement, right? So that is what you're looking at when you talk about the utility model versus the patent. Sure, it's an improvement. I would consider it a segue. Would anybody say that's a segue? That has some sort of improvement over but it's definitely not a patent, but it is a utility model. So what are the fundamental main differences between a patent and a utility model, right? So the first thing is that the utility model, right, is less, it's for incremental improvements. So therefore, it's less stringent to get on a patent. Can you imagine trying to prove this example as a patent? You'd have to show me where is the inventive step. The fact that I'm still using two wheels. Maybe I could go from the perspective that one probably uses a battery versus one using gasoline. Maybe that could be considered an improvement. But the idea would be very difficult for you to prove that you have an incremental improvement over what existed. So that is the fundamental, that decision would have to be made prior to you filing an application, right? That's one of the things that you're going to have to decide if you're going to, before you file an application, right? So also the other than the time frames being different, the documentation is the same, everything else is the same, but you do not have to prove the inventive step. That's what I really want to say. What you have to do is you just have to come up with the fundamental differences that are out there, right? And then you have to, one of the other fundamental differences is of the utility model and the patent is the cost. Now, the cost is, I would say, the most advantageous aspect of the utility model, because the cost, okay, so when you're filing a patent, other than the application cost, the utility model doesn't have an examination fee, so you don't have to go through the fact that you have to file examination fees. You don't have to do any of those things, right? So the processing is quicker, right? Because in the patent realm, one of the things that takes the lengthiest amount of time is to have the patent examined, right? So you don't have that process. So the utility model can actually go through to grant a lot faster than your average patent, and that happens in every jurisdiction, right? Then you look at maintenance fees. So you're looking at maintenance fees of a patent. Every year you have to pay an annuity to maintain that patent. And the rationale behind maintaining that patent is that the system wants to know that you're using the patent. You're not just sitting on the technology and not using it just to sit on the technology, say that I have a patent. But you're actually using and implementing that patent. So the encouragement for paying annuities is that you're utilizing the patent and you're commercializing the patent, right? So the utility model, in the same way like the patent, it gives you the exclusive rights over the invention for the time that you have the protection. And that's what you want. That's what every inventor wants. The time to commercialize and fully exploit their invention, right? It might not be 20 years like the patent, but 10 years I think is a good, if your thing is an incremental improvement, 10 years might be good, sufficient to commercialize it, because technology is so changing nowadays, right? So you have to look at that and you have to consider those things, right? So also, you want to consider the fact that the utility model has the benefits of just giving you the exclusive rights, right, for the thing. So technology has failed me, but anyway, not the screen this time, right? But so it does not have that examination of the utility model. So those are the things we're looking at, right? Now, one of the things that we're also looking at is that we have, the utility model is territorial, just like a patent. You have to seek protection in whatever territory that you're going to get that utility model. And that is something that you have to also anticipate, is that you're going to have to apply for that utility model in whatever jurisdiction that you're going to seek protection, which might be a situation where the utility model might not be offered in that jurisdiction, and that's what you have to consider. All right? Okay, so I'm just trying to, my technology has failed me, but okay. So, right. What should be done prior to filing? You definitely need to find out what is out there. If your technology already exists and you're making an improvement on that technology, you need to find out what exists out there and are you infringing. So it's good to do your due diligence, and it's good to know what is out there, because one of the things is if you've gone through the process and filed a utility model for something that already exists, you're not going to get it. It's always a first to file situation, and the first person to file is always the person that's going to get the utility model, right? Can I obtain both, a patent and a utility model? No. That's an interesting question. The answer is no, right? You can't have both. You have to have either one or the other. Because the rights are so similar, you have to have either one or the other. And this is very important to note, because I've heard people say that they want to have a patent and they want to have a utility model. No, what you'll have to do is before the utility model is granted, you can always convert it to a patent, right? But you cannot say I want to file a patent and a utility model. That's not how it works, right? And I'm just trying to. You want to have either or. You want to convert, so you have to make up your mind. Usually prior to filing the application, what you want to do, and maybe you can't help yourself, but the examiners at JIPA will say to you, okay, this is not a patent, this is not a utility model, you might want to consider a patent. And then what you will do is that you'll have to convert it, right? So Section 76.1 allows you to convert your patent to a utility model. and Section 78.2 allows you to do the inverse. So the legislation will allow you to convert, right? What is the cost for a patent? Now, this is something I've been avoiding deliberately. So the cost of filing a utility model is $10,000, which is significantly cheaper than a patent if you've tried to file one. The registration of that utility model is $3,500, right? And if you want to convert your application to a patent, it's $15,000. So it's good to know what you want before you come to JIPO, and it's good to know before so that you don't have to go through the cost of converting. Now, unlike a patent, as I said before, is that you don't have to pay a maintenance fee for the patent. Once you get the 10 years of protection, that's it, right? Now, the advantages of a utility model is that it is quicker and it's easier to apply for a patent, right? The utility model basically allows you to file. It gives you that whole structure of a patent. I think that's the basic advantage of the utility model. It requires not as much. It doesn't give you as much. It doesn't have as much. It doesn't have as much detail as a patent, although you might be required to file as much detail, but it doesn't. But it is really significantly cheaper. It's less stringent, and that is it. Thank you very much. I think I went over my time. But for further information, you can visit us at www.jipo.gov.jm, and you can call our offices. We're located at 18 Trafalgar Road. And you can come into the office and ask for anybody, and we'll give you the relevant information and the relevant assistance. Thank you. Any questions?
Thank you so much, Mr. Wong Sam. And I'm sure everyone is now aware of what a utility model is. And we have a question from Kadeen. She's asking, what if the utility model is an invention that exists, but you have enhanced it to meet the needs of the evolving industry? Okay. That is, the specific feature is new?
Okay, so that's a very good question. So what I was trying to say throughout my presentation is that you see that incremental improvement that you've made to the thing that exists already. That is where the utility model is. So you would be able to get that for that improvement that you've made to it, and that's important to know. So you can't apply for the whole pen itself, but you could apply for the top that you've added to the pen, and that's the utility model right there. So that's really good.
Okay. And for another question is, how do we actually conduct a search to find out if someone has a similar invention?
Okay, so right now you could do the searches at the IP office. We will search our database of inventions for you, or you can come into the office and do the search for yourself if you like. We're not online yet, but we're moving towards getting online, and we will be online in a short process. So that is. But then I also recommend that you can do your searches on Google Patents, or ESPASnet, which is the European Patent Office, or WIPO, which is Patent Scope, which will give you information of what is out there. And then you can come into JIPO and see what is in Jamaica. So that would be the best option for you to check both what is out there and what is in Jamaica.
Okay, thank you so much, Mr. Wong Sam. And I'm sure our viewers will have more questions throughout the presentation, and we will answer them in the chat. We will now have a brief conversation with Mr. Rayvon Stewart and the team from Sermasol about their journey as a beneficiary under the Patent Grant Fund here at DBJ. Rayvon Stewart, and as a young inventor, and also his experience as being a beneficiary of the DBJ's Patent Grant Fund. Thank you for coming.
Good afternoon, everyone. My name is Rayvon Stewart, founder and CEO of Zermosol. On behalf of the Zermosol team, we want to say a big thank you to the Development Bank of Jamaica for supporting the entrepreneurial ecosystem in Jamaica. This is evident through the National Business Model Competition as well as the University's Business Model Competition, where Zermosol was born. We also want to thank the Development Bank of Jamaica for their grants and support services that they provide. As it relates to our journey, Zermosol, which is a health tech company, was the winner of the 2019 UTech Business Model Competition. We then progressed to the National Business Model Competition, where we placed fourth. This was initially kind of daunting. However, we were selected by the International Business Model Committee, who gave us the opportunity to represent our country on the international levels. A turning point in our journey came when we were invited to the Commonwealth Health Ministers meeting in Geneva, Switzerland by Baroness Patricia Scotland, which gave 56 health ministers across the Commonwealth the opportunity to view our product. Upon returning to Jamaica, we knew we had to aggressively protect our intellectual property, such as filing our trademarks and our patents locally with the Jamaica Intellectual Property Office, or JIPO. The JIPO team definitely went above and beyond in assisting Zermosol in protecting our IPs. And for this, we must say a big thank you, especially to Mr. Wong Sung and Mrs. Herdsman. Based on some of our business processes, such as going through manufacturing, we knew we had to file for WIPO patent, as this gave us a lot more coverage. This definitely put us in a better place to do better negotiations with our potential investors. Now, I will yield the floor to Mr. Kirkland Rowe, COO and Director of Zermosol. He has played an integral part in the designing, filing, and receiving of the company's WIPO patent. Thank you very much.
Good morning. Just to share a little bit on the journey of the WIPO patent. It was something that we knew, as Rayvon said, that we wanted to do. And as part of the journey, we were fortunate and grateful for the grant we received from the DBJ, which allowed us to be able to apply for the WIPO patent. Initially, it seemed like an insurmountable task based on what is required. But fortunately, we had people around us who were able to provide the advice and the guidance that we needed. Particularly, JIPO played an important role in the initial advice. Then we were able to make connections with various persons who provided advice on where we could go, the lawyers we needed to talk to under the process. And the times to our share all to the others as well. So, some of whom really took an active role in advice. And so we are grateful for the pool of people, our advisory board as well, that we're able to judge on, who provided the guidance that we needed. Eventually, we were able to identify attorneys who had the required expertise to be able to assist us. And this is one of the things I'd encourage persons who are seeking patent that to get an attorney, especially an attorney who is informed about the particular process. Regarding the WIPO, we were able to get in touch with an attorney who had the expertise. From our initial meeting with him, we realized that he had the experience and the requisite background to be able to assist us. Another important thing on the journey that we did and we got advice is that we signed a non-disclosure agreement. Now, as part of an inventor's journey, as you interact with different people, people will always want to know about your product. It is critical that apart from the patent protection you receive, that as you have the various conversations, you ensure that your product is protected. So we were able to sign we got the attorney initially to sign the non-disclosure agreement. And then we were able to engage in very free discussions. Now, to get to file the WIPO patent, a vast amount of information is required. We had to prepare the technical specification for the invention. We knew we had an invention, but receiving the protection was necessary internationally because of where we expect that the product will be utilized. And so we had to prepare the necessary paperwork and the specification just to give to the attorney. Then the attorney, to his experience and team, who was not able to prepare the application, the document, and essentially converted our technical specification into the patent language that is required by WIPO. And going through that process, I required team meetings with the attorney, reading the documents over and over, back and forth, making sure that the idea and the concepts are clearly expressed. I'm an engineer, so I like engineering the language, but the WIPO patent application, it has to be very clear and written a particular way. And so the attorney was able to do that for us. Then once we were comfortable as a team, and the attorney as well was comfortable, the patent application was filed. And after that, it was awaiting it was awaiting a game that we waited for approximately 7 months. But while we were waiting, many other things were happening in the background in terms of the development of our product. Eventually, one morning, we got an email. And when I read the email, I wasn't too sure what the email was saying, except that there were some technical things that we needed to pay attention to. As an engineer, I'm reading it that way. I spoke to another colleague about the document, who in fact was part of the team pushing the WIPO patent process, and that's novel cook. And we spoke, and we were wondering if we understood what this was saying, because in essence it was a little unbelievable that what the email was in fact saying is that we had gotten the WIPO patent. And it was after we spoke with the attorney and the back and forth and so forth that we realized the significance of what actually took place, that we actually received the patent protection for all the claims that we had applied for. And it's a testament to the team effort. It is a testament as well to the guidance that we received from the attorney. And so we are grateful for all the different players who assisted us. We are grateful for the technical support that we have received for our partners in the development of the other product. And sir, tell I'm also grateful to Raven as well for the initiative for taking this part with regards to Zermosol. Raven.
Thank you, Mr. Rowe. Now, in closing, I want to say a big thank you to our CFO and board member, Mrs. Novlet Cook, who has been fighting for Zermosol from day one. I also could not close without saying thank you to the other team members, Mrs. Keisha Harvey, Andre Craig, and Kevoy Smith. And last, but by no means least, I want to say a big thank you to all of our shareholders and the advisory board. Thank you all.
Thank you so much, Raven, and Mr. Rowe for your very inspiring story. And I do trust that persons who are out there, whether you're an inventor or a researcher, you would have heard from Mr. Wong Sam exactly how you can go about navigating your application process through JIPO in terms of doing your search, drafting your specification, completing the forms, and the team at JIPO is willing and able to support you. We here at the Development Bank of Jamaica have our patent grant fund opened. It's an open window, so you can apply at any time. We pull applications at the end of the month. They will be evaluated and you will receive a response in 30 days whether you are supported. Just like Raven here, you could be a beneficiary of the fund of up to $4 million to support you with filing your application here in Jamaica and in any other jurisdiction, to assist you as well with securing an attorney, to assist you with your specification and any other documentation that you may need to file your patent. So on behalf of the team here at the Development Bank of Jamaica, we just like to thank you for joining our webinar. It's the first in our series, so we'll definitely have another session speaking to you more about intellectual property and how you can actually receive grant funding to secure your intellectual property in your innovation. Thank you so very much.